State versus Tariq gathers. Can we please have appearances of counsel?
Good afternoon, Your Honor. Deputy Attorney General Lila B. Leonard, on behalf of the Attorney General, President Kevin Fitzgerald.
Good afternoon, Your Honor. This is Commercial Finance Prosecutor Joseph Tariq, on behalf of the County Prosecutors Association of New Jersey, appearing as amicus curiae.
Good afternoon, Your Honor. Chanel J. Hudson, Assistant Deputy Public Defender, joined by my colleague, Caitlin Flood, on behalf of Respondent Tariq Gathers.
Good afternoon, Tess Gordon, admitted pro bono on behalf of Amicus American Civil Liberties Union of New Jersey. I'm joined by my colleague, Alexander Schultz.
Welcome, counsel. Please be seated. We have a motion to dismiss. We're going to, as you know, hear argument and resolve that issue later. You're welcome to address it if you like, but I would suggest we get to the merits rather rapidly if you do. You're welcome to rest on your papers as well. Ms. Elson.
Good afternoon, Your Honors. May it please the Court. The precedent set by the Appellate Division's published opinion in State v. Tariq Gathers requires a level of probable cause that is above and beyond what is required by New Jersey case law and leaves the State in a catch-22 situation, given NDIS operational procedures and State laboratory protocols. The DNA Act established a State data bank and database of DNA profiles of certain convicted and arrested offenders. There is language throughout that statute that clearly indicates the legislature's intent that our database be kept in compliance with the federal guidelines and standards for the federal database. Indeed, the records in our state database are forwarded to the FBI for inclusion in their federal database. And that is significant in that each state that is part of the federal database must comply with the federal guidelines and procedures, or they cannot submit anything to that federal database. One of the utmost concerns in establishing the federal database DNA profiles and CODIS generally was the privacy of the individuals whose DNA profiles would be contained in the database. From the outset, no personal identifiers were to be used in terms of cataloging the DNA profiles, and no personal identifiers were to be used in the retrieval of those DNA personal identifiers. This is exactly what the Appellate Division's opinion requires now of the state and the state lab, is to search the CODIS database by personal identifiers, because that is the only way to go in and select a previously convicted or arrested individual's DNA profile from the database. Additionally, also problematic is the fact that not all DNA records are eligible for upload into the CODIS system. For example, a case such as Mr. Gathers' case, where we have a possessory offense. Possessory offenses are not eligible for CODIS. They cannot be uploaded into the system. So again, in the instance of a possessory case, the Appellate Division opinion requires skirting the guidelines and procedures that have been set forth from the federal CODIS system that pass down to the state CODIS system. With respect to chain of custody, there is a significant issue with chain of custody with regard to requiring the state to use profiles that had previously been submitted under the DNA Act into the CODIS database. Simply put, the state will never be able to establish a chain of custody on a convicted offender sample or an arrestee sample because we don't have control over chain of custody throughout. They're sent through the U.S. mail. They're swabbed, it's put in the mail, and it's mailed in for it to be submitted to the database. So without that chain of custody, there is the only way possible to absolutely confirm that the DNA to be compared is, in fact, the defendants that we are testing, is by way of a reference sample. Additionally, CODIS was set up to be an investigatory tool. It was meant to provide an investigatory lead, not a full DNA match, with an accompanying certified lab report. What is generated as a result of a CODIS hit is not a certified lab report. It is a letter that indicates to the investigating agency that they have an investigative lead, and it indicates to that agency that there is a need for a reference sample so that the full testing can be done and a match can be determined. And the reference sample that is required serves also to protect a defendant in this position. It's the only way to confirm that the DNA we are talking about does in fact belong to that particular defendant. With respect to the issue of probable cause as raised in the Appellate Division's opinion, the Appellate Division opinion disallows hearsay to establish probable cause to compel a buccal swab. And it has been well established that courts may rely on hearsay to establish such probable cause. It is done significantly recently in the criminal justice reform system. State proceeds by way of proffer. There is hearsay obviously contained in the documents that would be submitted when there is one officer that is drafting those documents. As this court is aware, probable cause is not a high burden. It does not require a certainty. And the approach that should be taken to this is the totality of the circumstances approach in evaluating the existence of probable cause. This is, although in this case the seeking of the buccal swab came to the court by way of motion, what we are looking at is a search. And the analysis of the hearsay aspect to establish probable cause should be addressed in the way that it is when we're discussing searches and search warrants. And that is a qualitative, not a quantitative analysis. We're not looking for a percentage of hearsay that's contained in an affidavit or certification that contains hearsay. Our case law provides that there must be substantial basis for crediting the hearsay to permit a court to rely on it.
Can we go back to certain basic questions? I didn't want to interrupt your first 5 minutes. It stands to reason that if you want to test the DNA that exists on a gun or may exist on a gun and compare it to some other sample, the first thing you'd need to know is there DNA on the gun that could be used for that comparison? Would you agree?
Yes and no, Your Honor. Is
there any point to doing a comparison test if there is no DNA on the gun?
No, there is not. Obviously, there would be nothing to compare it to.
So why wouldn't the starting point logically be, let's check if there's a sufficient sample of DNA on the gun that would permit a comparison before you then try to get a sample from a particular suspect?
Your Honor, the state would be the argument would be one of public interest, essentially. There is an interest in all parties involved to move the process along in the most efficient manner and to minimize delay.
It would be inefficient to get the DNA from the gun first?
Not so much the inefficiency comes, it's not necessarily inefficient, but...
I'm just using the word you used.
Exactly, but there's a time, we're talking about a time delay. Obviously, DNA testing is not done, it's not an overnight process. It does take some time.
Was the gun in your possession?
The gun was in our possession, yes.
But there would be a time delay as opposed to going to get a buccal swab?
The delay comes in that the DNA swab then from the gun goes in, has to go through the full administrative process at the lab, and all of the processing that then happens. And this is in a scenario when we're talking about where we
Doesn't the buccal swab have to go through all that process too?
It does, but when they're sent together, the administration is cut down. The time lag is shorter.
How long does it take to send any kind of slide, whether it be a cigarette butt, a gun, whatever, to get from the state police a statement that it does or does not have a testable sample?
It's my understanding that it's not so much they don't necessarily just test the piece of evidence for just the presence of DNA. So they run the full profile. At a minimum, they're going to run it.
I'm just asking because I could be wrong. I've been going a long time. You're representing to me that when you have a slide of something and you want to see if it's got a discernible if it's got DNA on it, you can't find that out in a short turnaround time? You can't tell them simply, don't run, we'll have a detective deliver it, you just let us know ASAP.
My understanding is at a minimum, it takes at least 1 to 2 days to do the processing. However,
is that to determine whether there's DNA on the slide?
I believe it's my understanding as well that when they're testing, they're not just they're determining DNA is there, but they're getting the profile as well. But that's assuming they have nothing else to do, because when it comes in, it's going to the back of the queue.
I never assume that. I'm just asking.
So we know what happened in this case.
Yes.
And I credit the state for turning over the materials you did on Friday. But this offense took place in August of 2015. The gun was found August 21st. Is that about right?
I believe so, Your Honor.
On the day of the incident, the gun was recovered? And it wasn't for the better part of a year that the materials were submitted to the lab, June of 2016?
That is my understanding.
And then a turnaround 10 weeks or so after that.
The
Correct?
lab report that the state turned over indicated a date of, it was sometime in August.
August 27th, June 23rd, and then August 27th. The question is, if you have to make a showing to a judge, take this case, had it been turned over early, would have been 10 weeks, why not first check whether there's DNA there before going to a defendant and trying to take a buccal swab?
Your Honor, as I argued before, it's an argument of making sure that the system proceeds in the most efficient, quickest manner possible.
So let's take that, because this seems anything but efficient. I'm looking at the certification. Tell me if I'm April 22nd, 2016. Do I have the right document before me? You're asking for the buccal swab in April of 2016? Am I correct about that?
Yes, Your Honor.
And yet you don't submit the gun sample until June of 2016. How does that make any sense at all?
Well,
You're asking for the swab from the defendant who has a Fourth Amendment interest against unreasonable searches and seizures months before you've decided to even submit to the lab the DNA sample from the gun.
the procedure from the lab is that the evidential sample, which in this case was the gun, goes down simultaneously with the buccal swab. The court's order was not signed until June, I believe it was 27th. So they sent the gun down in advance of a few days of the order, but it is intended to be simultaneous submission.
Clarify that. Was there a buccal swab sent along within a few days?
I don't know that there was a buccal swab sent in this case because there was then the appellate application.
Right. Has the buccal swab been taken?
Not that I'm aware of.
So, and that's what's confusing me. The argument is you've got to send them both together, but this case shows us that you don't. Which is the rule?
The lab will make exceptions, obviously, if there's some sort of emergency, if there is something that comes up in terms of a trial issue. Now you're facing a trial and you have a weapon.
So lab's supposed to be guiding how we interpret the Fourth Amendment?
No.
The lab will decide whether it's an emergency, whether or not to test the DNA. Where the defendant has a Fourth Amendment interest against unreasonable searches and seizure, and he doesn't want an invasive procedure unless you have an identifiable piece of evidence against which to test his buccal swab. Is that unreasonable?
No, but the state would argue that the buccal swab is and has been found by this court to be minimally invasive. It is much less invasive.
But why
than taking
take
blood.
it if you don't have anything against which to compare it to?
Again, the lab policy has been that they come in together for efficiency purposes so that there is not double the process in terms of taking everything down.
Understood. So come to the stage where there's a judge, and this is why these preliminary questions matter, I think. How does the judge know whether there is a sufficient showing that the buccal swab should be taken if the judge doesn't know whether there's anything to compare it to on the gun? How do you make your showing?
It's a probable cause standard. So it's whether there's probable cause to believe that there will be DNA on that piece of evidence. Based on the factual circumstances of this case, there was sufficient probable cause to establish that belief. The fact that the gun was recovered, we have a defendant who ultimately admits to detectives that he shot himself. So.
Aren't there two pieces to the probable cause as you're teasing it out? One is is there probable cause that this defendant handled the weapon in some fashion, right? Number two, is there probable cause to believe that this defendant's DNA was left on the gun and thus you will get evidence from it? Can a court assume that?
I think in terms of given the fact that probable cause is such a low standard, you can establish that there is probable cause based on the conduct that has been established to indicate that there may well be DNA on the evidence to be tested.
There's a way to find a yes or no answer, and obviously you're dealing with the burdens that are on the lab, and you're dealing with obviously time constraints. But I haven't read anything in this file or heard anything from your argument that suggests that it is not feasible to take as a first step, send the gun to find out yes or no, is there usable DNA on it. That ends the issue. If there is not, if there is, then you walk into the court with there is usable DNA on this gun, and you have a very strong showing that you can make. So, is there a logistical barrier to that kind of process?
There is not an absolute bar to that type of process, no.
Could that process happen in each case? What would be the consequences of that?
If we were to require this process in every gun possession case, there will be a slowdown. There's given the backlog of the lab, just logistically proceeding. Obviously, everything goes in order of it coming in. There are cases that are going to get prioritized by virtue of what they are, obviously things like homicides and sex assaults and things of that nature. So,
how often in gun possession cases, if you can estimate for us, does your office send off the gun for a DNA test?
The guns, it's my understanding that all guns are now swabbed
right.
They're swabbed, but they are not all necessarily sent down for testing. It depends, obviously, on the procedural and factual tenor of the case, whether or not it's something that's going to trial, and how it proceeds there. Obviously, if we have a case that ultimately results in a plea agreement, there's not going to be any testing of a weapon.
And what if there's a case where there's no question that the individual had the gun, it was on the individual when he or she was arrested? This is an unusual scenario here. You have the gun in one place and the defendant in another, and obviously there has to be a link, and you want a DNA to be that link. But how often does it actually come up that you have a possession offense where you have the defendant and a gun found in different places? Pure possession.
I mean, it would be speculation on my part, but it's not as uncommon as Your Honor would think. And the fact that we necessarily have a case where an individual is arrested physically in possession of a gun doesn't necessarily dictate that we're not going to send it for further evidential testing, given the sort of the advent of the world that we are in terms of the CSI effect, for lack of a better way to put it, when we're addressing juries and we have to face arguments of where was the DNA, where were the fingerprints. So even in those cases, if it's facing trial, there may well be DNA testing that has to be done.
Do you think, in answer to the Chief's question about probable cause to believe that there's going to be DNA on the gun, I don't remember specifically, did the certification or should the certification have on it the reason to believe there'll be DNA on the gun? For example, reason to believe that it was handled by whoever. Was that in the certification? Would that help?
There was not a comment in the certification that there was reasonable belief that there would be DNA on the gun, but I think based on the facts that are contained in the certification, the judge could have made that conclusion based on the admissions that were made and the way the gun was obviously stored, the fact that there was an admission that it had been tossed, so obviously it had been handled.
I know that almost never do fingerprints turn up on a gun, because they had fingerprints back in my day, a long time ago. Didn't do as much DNA. How often does DNA show up on the weapon?
I can't necessarily give Your Honor a percentage. It's not, I don't believe it's as common as we would hope or think. Has there been DNA on weapons? Yes.
Is it common enough to say to the court, we believe that this was handled by whoever, and in 70%, 60%, 20% of the cases, it reveals DNA. A doorknob can reveal DNA. Certainly a cigarette butt reveals DNA. Is there any way to make that representation in the certification?
I don't know that is necessarily able to be made in the certification, but what we are facing is if we have we now have a directive that says all guns have to be swabbed. So now I'll give you the scenario of we have a case that's involving a gun. It's a possession case. The gun has been swabbed, and it's going to trial. So in order to be able to proceed, we're faced with the argument of, well, if the state swabbed the gun, why didn't they test it?
No, I think it's somewhere else for a minute. We've been talking about the gun and whether the gun should have gone to the lab first and then the swab or vice versa. What is it exactly you need to access CODIS? You said initially that you needed, that you couldn't use personal identifiers. In order to get into the database, what exactly is it that you need to...
They're stored by essentially like identifying numbers. I don't know if it's tracked through SBI numbers or something, but every profile is assigned sort of an identifying code.
But in order to get to that, what do you need? You need the swab?
I mean, there is technically, could you end run the system and go
I'm not
back
asking you to
in?
run anything. I'm just asking you what you need actually. I'm not asking for an end run. I want to know exactly what it is that you need to access CODIS. Do you need the swab from the defendant, from the individual? Do you need proof of the gun? Can you just access and say, we believe that you may have a sample here that might match the gun? What exactly is it that you need to get the CODIS?
There needs to be a sort of an unidentified. The purpose of CODIS is to provide investigatory leads as to identification of a suspect. So if you have, and that's why a gun possessory case is not eligible for CODIS. If you have an unsolved crime in some instance, say you have a homicide, and body's laying there and the gun is laying next to him, that's an unknown suspect. Swab the gun. If there's a DNA profile, that DNA profile gets uploaded.
Without swabbing the gun, can you access CODIS to get that first, the profile, or do you need
No, the profile is submitted to CODIS to determine if there's a hit.
Okay.
And then at that point in time, if there is a hit, the investigative office is notified, and they are obviously told to get a reference sample from that individual.
Why wasn't this an unknown suspect at this point? It's not as though the gun were found on the defendant. The reason why you were doing the DNA sample was to see if you could connect him to the gun. It could have been someone else. Like I don't understand why this wouldn't be a CODIS type case.
Well, possessory offenses are not CODIS eligible. So right off the bat, just a possessory offense is not CODIS eligible.
I mean, is that a state rule or a federal
That's
rule?
the federal code. That's in the guidelines. It's actually in the NDIS procedures and operational manual that the state submitted. Possessory offenses, they specifically reference an item having to be used. It references the use in a crime. Mere possessory offenses, there is not a use to be tied.
Is that a matter of priority? They're looking to devote CODIS to presumably violent crimes for the most
Exactly.
part.
They're looking to focus on the more serious offenses to either identify an unknown subject or possibly prevent in the instance of like serial crimes to prevent further crime.
So you're telling us that if you strictly followed the federal guidelines, you were not permitted access to CODIS?
To search by personal identifier? No.
Yeah.
Come back for a minute, if you would, to the threshold showing that needs to be made. It may not be that high if a scientific expert could say, in a majority of cases, or it's more likely than not, that DNA will be capable of being removed, will be removed from guns that an individual has handled. And that could find its way into certification in the future. Is there evidence that supports that? Is there an expert who would say that? And if not, how can we just assume it?
I don't know that there necessarily is. I think there's probably a lot factually, specifically to each instance of the gun being handled, how it's been handled, how often it's been handled, where it's been stored, things of that nature that will play into whether or not there's DNA left on any specific weapon in any given set of circumstances.
Would that be helpful for a judge to make an assessment of probable cause?
It could be, yes.
Standard?
The state would submit that it could be. But given the factual tenor of this case, the state would submit that there was enough to believe that there was probable cause that there could be DNA on that weapon based on the way the gun was handled and the nature of it.
I want to come to the right standard for a second. Maryland versus King dealt with a booking situation. It spoke about this in Fourth Amendment terms as a search. Did you canvass case law in other states and in the federal system for efforts to obtain a buccal swab after a booking situation? I'm not looking to put you on the spot, but is there law out there that might be able to help this court?
Not that I am aware of, Your Honor. The standards that were contained in the state's brief are the ones that the state is aware of.
So perhaps the Attorney General can help us as well. Whether that's been canvassed is my question. I'm not looking to put you on the spot for the answer at the moment. Right?
That may be a question that is better directed.
Before you sit down, on the form that you forwarded to us on Friday, the evidence receipt, do you have that handy? I just have a question about the last sentence of the narrative paragraph. Sure. It says, per Maureen Lobier. Do you have it?
Yes.
Should a DNA profile be found, buccal swabs of the defendant will be immediately forthcoming as a court order to compel is necessary, but cannot be obtained until DNA is located on the weapon. So is that submitted from your office?
This comes from, this paragraph is done by one of the detectives, the detective who does the evidence request and
It just
processes
seems so
it.
inconsistent with the position that's being argued by your office. I could not reconcile this statement with what we're hearing in argument.
And I recognize that, Your Honor. But again, this is from one of the detectives. I don't know that he would necessarily be as well versed in terms of the process of buccal swab and in terms of taking
You're
of the
saying
buccal
this is
swab.
not the practice of your office to not seek a buccal swab through court order until after a specimen, DNA specimen, is known can be obtained from the gun?
Correct. It has been our office's procedure to attempt to send
Who's
both
Maureen
together.
Lobier?
Maureen Lobier works with the laboratory. I don't know what her exact title is, but she is with the Office of Forensic Sciences laboratory.
State police?
Thank you.
State police? Or your office? Do you have a forensic?
Not our, no,
Okay,
not
I was
our,
just-
yeah, state police, no.
Budgets have changed over the years.
Doesn't have its own laboratory
I just
for
have
that.
two really quick questions. You raised the point that you swab all guns, and the defendant is always going to say, did you get DNA? What did the DNA show? Just as they used to always say, why didn't you take fingerprints? Now they try to fingerprint and get almost no results on the gun. Is that one of the issues you're trying to foreclose? In other words, I'm assuming every smart defense attorney is going to raise that question if they know there's no testing for DNA or, frankly, fingerprints on the gun, because they do. Is that what kind of motivates what's going on here?
Absolutely, Your Honor. That's one of the issues that comes up, obviously, especially in a trial situation. So that's one of the issues that we're trying to foreclose, and
So
why
whether-
it comes up when you have a case that may eventually be going to trial, not necessarily a case that results in a plea
And the
early
only
on.
way to deal with that is to dust the gun for fingerprints, even though it'll show none, and test the gun for DNA, swab it, even though it may or may not show any.
Absolutely.
So that takes us to the resource question that you were ably putting forth before. If we're talking about a small universe of cases that may go to trial, correct?
Correct.
And can you or perhaps the AG help us understand whether that grouping of cases would create the resource issue if you had to send the swab from the gun down first to determine whether there was anything on it to compare before you went to the defendant?
I think arguably that it could create a resource issue, just in terms of efficiency, based on even if every county only had 2 such cases in a given year, it's going to have an impact on the lab and the work that the lab is doing in terms of wait times as well, given all of the other cases that they're doing.
But isn't the laboratory always going to, as a matter of procedure, test the gun swab first, and if nothing comes up, stop there? They're going to at least call your office.
If they will test the gun swab first. If there's nothing found, it's my understanding they then take the buccal swab. It gets sent back to our office.
Right.
They do nothing with it.
So, in every case, it's going to be the same. They're going to test the gun swab. If it's got DNA, they're going to test the buccal swab. If it doesn't, they're going to throw it away. And that's going to happen in every case where you need a gun swab DNA testing.
Correct, but it's going to happen if you have a case where you have DNA in the gun. It's going to happen in a much faster time frame because the buccal swab is there and it's ready to go, as opposed to then having to be sent back, the information having to be transmitted back, then having to get the buccal swab, have that sent in, have the administrative process be done.
Okay.
To then test the buccal swab to be able to then do the
But
comparison
you're making
between
these
the two.
submissions for unsolved crimes. You have no problem submitting the DNA sample, correct?
I'm sorry.
Before you have there are many crimes that are committed and you don't have a suspect at the moment. You swab the scene for evidence. You find DNA. You don't wait until you find the suspect. You send it to the laboratory. They get a DNA profile. Yes?
Correct. Because we're attempting to identify someone as opposed to having someone who is
I
maybe in custody.
I get it, but I'm just pointing out you have no problem submitting a DNA profile without having something to compare it to immediately. Correct? It's not a big deal.
Well, if we're attempting to identify a suspect, obviously we're trying to determine.
That I understand. Can I ask you a question about the certification?
Sure.
And this goes to probable cause. So we all know that hearsay is permissible for probable cause. But even doesn't hearsay have its limits, requiring the affiant or the person who's certifying to at least give the basis of her knowledge of the information, so that the court can figure out the basis of knowledge, which seems to be totally absent in this certification.
There is no stated basis of knowledge within, obviously.
But not in this one, but shouldn't there be? If you don't have personal knowledge, and we're not saying that you need personal knowledge for probable cause, shouldn't you at least be giving the basis of your knowledge, so that in this case, if it happens to be Officer A, B, and C, that you got the information from Officer A who observed this, Officer B who did that? Totally. Don't you think that should be in the certification or affidavit?
That may be appropriate. The state would submit, obviously, in this case, the assistant prosecutor who was handling the file, obviously, is who submitted the certification. Obviously, that assistant prosecutor has access to the police reports and the discovery and is fully aware of what
But how would the judge know that unless it stated it? I heard this. I reviewed this. How can the judge determine the trustworthy? First of all, it's hearsay, of course, so it's not that trustworthy. But how can the judge determine where the information comes from if there's not a preliminary statement saying where it was obtained from a police report? Should the judges assume, well, he's a prosecutor, so he must have looked at a police report? He probably talks to police officers all day, so I'm sure he talked to the right one here.
Well, I would submit that as prosecutors, we're obviously officers of the court. We're held to a certain standard as far as ethical obligations and
that solves the hearsay problem. I'm a prosecutor. I'm an officer of the court. Attorneys are officers of the court. Can they, who are not prosecutors? Every attorney is. Should they be allowed to come in with a hearsay statement without a basis or for the knowledge of for the hearsay statement where it came from?
Well, I think it would have been easy for the court to recognize that in this case that the prosecutor who had the police reports and referenced the information that was contained in the police reports.
How did the judge know that the prosecutor had the police reports?
I would hope that the judge would know that the state has
really?
the police reports.
You have 100 cases, somebody comes in and makes a bold statement, the gun might have DNA on it, and the judge is supposed to know that it must be said because it was the prosecutor's had the police report, he reviewed it or she reviewed it. Is that the way it works?
No, but this
because if it is, I did it wrong for a long, long time. Because I was on the bench down there for a long time, and if that's the way it is, then I must have got it wrong all those years.
This certification details the
It's
sort of the unfolding of facts as it happens. Obviously, the prosecutor wasn't
Would you
present.
at least so it's a narrative?
Yes.
And you might be able to infer it's coming from police reports. Because you're going to be going back to your office, right, giving advice. Don't you think that the certifications and affidavits should set forth the basis of knowledge
Would that be the best course of action? Yes, Your Honor.
and the appropriate course of action?
Correct, Your Honor.
Okay, thank you.
Is there a preference, one way or the other, in the office to ask a detective with some knowledge as opposed to the prosecutor to make these certifications?
I don't know that there's ever been any sort of set directive to do it one way or the other. Obviously, this case will guide us going forward in terms of how these types of applications are made.
Thank you.
Thank you.
Ms. Leonard.
Good afternoon, Your Honors, and may it please the Court. The Appellate Division's decision is not moot and must be reversed, both for the problems with the redefined probable cause heightening the standard, because probable cause is and always has been nothing more than a well-grounded suspicion, and also because the decision has put the lab in a position of either ignoring a published Appellate Division decision or violating state and federal law, thereby risking its accreditation and ability to participate in the National CODIS program. And there's also, I want to jump into what was discussed before regarding the inefficiencies with the timing of getting a buccal swab with the evidence. Because there's an important policy reason for getting them simultaneously. And this is a sort of a traditional Fourth Amendment balancing test. On the one hand, we have the government's interest, where the state lab has this policy for a very good reason. Testing for DNA is not as simple as shining a black light, for example, to see if touch DNA is there. Touch DNA is very different in that respect from bodily fluids. In a vacuum, the way that this works at the lab is that a piece of evidence comes in. It has to maintain chain of custody, so it comes into the lab and then it goes into the DNA unit where it is swabbed. It's assigned to an analyst who then walks it through a 4-step process. That 4-step process can take a day and a half to 2 days if that's the only thing the analyst is working on. And then at the end of that, the analyst looks at that data and analyzes whether an acceptable DNA profile has been generated. It may have a partial profile, it may have mixed profiles from multiple donors, which then they can't use. So they analyze that data and write a report. That report then goes through 2 levels of supervision. It's peer-reviewed, and then it's reviewed by a supervisor, and then it's mailed out. When that is
Can I stop you right there? Is this report, does it accomplish both, does it answer both the question, is there usable DNA, and what is the profile of that DNA? In other words, are both of those functions incorporated in what you just described?
Well, I think it depends on what's in that report. If the buccal swab is submitted simultaneously with the piece of evidence, then it can compare the...
Let me ask it a different way. Is there a way to shorten the process if the only objective, if all the lab is being asked to do is determine whether or not there's usable DNA? No profile needed. We don't need to know the profile yet. We have one question, and that is, would this sample provide you with the opportunity to create a profile?
No, Your Honor, because it's not a matter of is there DNA or not. It's is there a usable profile. That's the information that they have to have. And so the reason for the policy of requiring the buccal swab at the same time that the evidence comes in is that then those 2 pieces actually are tested simultaneously. And they're done separately, so there's no cross-contamination concern, but they're done at the same time, and then that report is written once. There's one report.
That makes eminently good sense, what you've just described. The question, though, is, what does the judge need to know, and what does the state need to show in order to get the buccal swab to begin with before you can send this package down to the lab? How does a judge know from a certification like this, not simply that the defendant may well have handled the gun, but that there could be DNA sufficient for a comparison found on the gun, without some expert giving a little bit of guidance in that regard?
Well, it's just a probable cause showing, which is not more likely than not. there's a fair probability that DNA will be on it. And here we've got a certification where we know that there's a very good likelihood that this gun, this revolver that was found on the ground, is the same revolver that the defendant had admitted to shooting himself with and dropping on the ground.
Let's get away from guns. Suppose there were money that were seized, cash. Could you get a buccal swab from a judge in order to test for DNA on the piece of paper? And if not, why not?
I think it depends on the charges, but
No, I don't mean that. I'm trying to figure out if you'd be able to represent to the judge there's a sufficient basis to believe DNA will have been captured on this $20 bill.
okay.
Is that something a judge can assume?
Well, I think there has to be some showing of probable cause to compel the buccal swab to show that there is.
Right, so let's assume you can demonstrate sufficient probable cause to show that a defendant touched the piece of paper. Is that enough?
Yes.
See, I'm having problems, and for the reasons identified by the Chief Justice, it seems to me that there are two probable causes. You have probable cause to believe that he possessed the gun. That's the reason why you charged him. But now the question is whether or not you have probable cause to invade his body. And that probable cause decision, you would think, would be premised on you having an identifiable DNA profile, in the absence of which you'd have none.
Well,
why aren't, I know the Chief Justice asked this a couple times, but why isn't that two-step process the paradigm that should be followed?
Well, the invasion on the defendant is weighed against the government's interest.
But you can't have any interest in invading someone's body if you don't have an identifiable piece of evidence from which to compare the buccal swab.
But if there's probable cause to believe that DNA is on the weapon, then that's what's weighed against the minimal intrusion.
How do you show that? How do you show that? And did this certification contain any information that would lead the judge to believe? Sounds like they might find DNA. Not going to find it. Not even that it's more likely than not they'll find it. But I get it. They might find DNA on this. They got to match it up. What did this judge have? And if nothing, what should a judge have to tell them there's a reason to at least check this slide? What do you need to show, if anything?
I think the probable cause showing that the defendant possessed the weapon is sufficient to show that there's a probable cause there might be DNA.
Now you come back to my first question. Well, I think it was my first question. I used to think, because I not that I ever watched CSI, but I watch enough shows, and they're always dusting the gun and the doorknob and everything for fingerprints. And you assume that fingerprints turn up on guns. And I didn't realize they never did until I talked to a homicide detective. And he said, no, I think I got it off one gun in 25 years. Now.
So he stopped watching television after that.
Completely.
And it's in color
so
now.
What do you... yeah, they just started making televisions at the time. So what if anything, I'm not saying you have to, what if anything do you have to give to the judge to say, there's reason for us to have this test and compare it to this defendant who we think handled it? Whether it's paper, whether it's the gun, whatever. What if anything?
I think a probable cause showing that he handled it is enough to show that there's enough to do the minimal intrusion of the buccal swab just to see if you can compare.
Doesn't have to say that. Go ahead. Doesn't have to say that in 5% of the cases, 1% of the cases, 2% of the cases, we turn up DNA.
That information might be helpful.
Is it necessary?
I don't know that it is, but
it strikes me that it would be very simple to provide this information. You could have a paragraph, as I suggested earlier, that says, an expert has opined that in more than half of the cases, when an individual handles a gun without a protective device, DNA is left behind. But you don't know the answer to that. We don't know the answer to that. Are you simply asking us to assume that, or shouldn't we at least know that information?
Well, as a practice, we know that DNA is sometimes found, and I did try to pin down
Sometimes.
the percentage of the before the argument, and I didn't get an answer in time. But
And it may not be, there may not be a meaningful statistic on that, because that would be only on the guns that are tested. In other words,
correct.
that may not be your actual a proper sample from which to make that determination.
Correct.
You know, here's the problem, if I could. Again, try a different realm. You have evidence of a victim's clothing. You have no visible evidence of bloodstain on it. Can you go to a judge and try to get the defendant's blood sample for a comparison?
Well, that changes the narrative slightly, because there you have a victim, so it's not a possessory crime. And if you've got a victim, then that piece of evidence is eligible for inclusion into CODIS.
No, but you're into CODIS, and I'm focusing on the showing required in order to get a blood sample from the defendant, from the putative defendant. Do you have to at least say, Judge, there's a reason to believe that there's something to compare to before the judge has enough to give you authority to take the blood sample? Do you understand my focus?
I think you're saying, Your Honor, that you have to have a reason to believe that there will be a defendant's DNA
That there'll be evidence.
on the piece of clothing before requesting the buccal swab.
Do you think that's not necessary as part of a showing of probable cause, that evidence will be derived from the buccal sample?
I think that is a part of a showing of probable cause, but again, it's a very low standard.
It wouldn't go as high as to suggest to my colleague. You have to show the judge that there is DNA on the sample before you can get the swab. It would just be this probable cause to believe that there's something on it. It wouldn't go as high as that, but it certainly would be more than just saying we want to take the buccal swab.
Yes, Your Honor, there's probable cause to believe.
So we keep on talking about probable cause. I just want to go back to certain words in the Fourth Amendment. Unreasonable search. Okay. Which presupposes a reasonable search.
Mm-hmm.
So why wouldn't a reasonable search only be predicated upon, and particularly when the search is going to be invading someone's body, something that you actually have a basis on which to compare it to? Reasonable. Unreasonable searches.
Exactly, it comes back to reasonableness. It is not unreasonable.
How could it ever, I'm trying to figure out, how could you ever have a premise for a reasonable search when you don't have an identifiable DNA profile?
Well, it's akin to fingerprinting, Your Honor. I mean, we're looking at, it's a balancing test. The intrusion on the defendant is weighed against the government's interest. And frankly, a buccal swab takes less time than fingerprints. And these are they've been recognized by this court and the United States Supreme Court and Maryland v. King as a minimal intrusion.
It's fine, but I mean, I understand the interest, but you still have the Fourth Amendment. Like, I just don't. It seems to me that you're arguing that convenience overrides constitutional protections.
It's not convenience, Your Honor, but not by a long stretch, because the process that I was walking through before, that's when the lab has one piece of evidence to work on. But we know the reality is they have a backlog of 6 months for personal crimes and 14 to 16 months for property crimes, and they're working with thousands of pieces of evidence a year. Obviously, the violent crimes take precedence over possession cases, and then there's criminal justice reform and speedy trial concerns. And so the lab is working very hard to keep its head above water, but asking the lab to double its workload, essentially, by making them do the entire analysis process twice and write 2 reports, have them reviewed by the peer and then the supervisor twice, making them slow down hurts not only the lab and the state in investigating crimes, but then defendants' cases are slower to get to trial, and their cases move more slowly. And for that matter, the Innocence Project has access to the state lab, and their clients are sitting in state prison waiting to see if the DNA will exonerate them.
Can you give us numbers of the volume of samples that relate to what you've just described for us?
I know from NIBIN that they see about 3,000 gun cases a year, and so I know they have based on the backlog, I mean, that tells you there are thousands of cases. I don't have exact figures for the number of cases in total that they're assisting, but I do know that since the inception of, since New Jersey started with the CODIS program, there have been more than 12,000 hits that have led to investigative leads. So they, and that was, I believe it, I don't remember the exact year off the top of my head that they began, but that shows that, I mean, those are the successful cases, as opposed to here where, you know, they had all this work to do, and then in the end, there actually wasn't DNA. But even if there had been DNA on the gun here, then there's nothing they can do with it without a buccal swab, because they can't upload it into CODIS, and so it has to sit there and wait to see if there's a swab. So if, you know, if the judge denied the motion to compel, or if the defendant absconded, then all that work that they did was for nothing, because they can't do anything with it. And if they do get a buccal swab, then they have to go through the entire process again. And the evidence should sit in the backlog both times, because otherwise then the criminal justice cases and the more violent crime cases get pushed aside when, for example, if a judge is asking to move things along more quickly, then they can work more quickly, but that pushes everything else aside.
Your colleague has told us that guns are being swapped in all of these cases now?
NIDN swabs all the guns, and then they just store it unless they have a request to send it along.
Would this whole debate be obviated had a buccal swab been taken at the time of booking?
But we certainly wouldn't be here arguing this. If the buccal swab had been given at booking, then they could have gone through the process, and there wouldn't have been a problem. But
so Maryland versus King tells us that you don't need probable cause in all these circumstances. You certainly don't need it at the time of booking, correct?
Correct.
Focusing on Justice Albin's question to you earlier about the reasonableness analysis that must be done, are you conceding that probable cause has to be shown in all of these cases? Have you canvassed other states and federal law on this issue?
I'm absolutely not conceding that. And I did, when I was writing my brief, I did do some quick research on other states, and I don't believe I came up with anything. I remember searching to see what other states were doing, and didn't come up with a whole lot. I don't remember the exact issue I was searching, but if it had not been done at the time of booking, and sometimes there's very good reasons that it can't be done at the time of booking. I mean, sometimes there's a lot going on in the station house, and it falls through the cracks for whatever reason. I mean, maybe there's inmates fighting, or just a flurry of people coming in, and they don't have the opportunity to do it. The government's mean doesn't diminish as the defendant sits in a jail cell, and there's no principal distinction between being processed into the jailhouse and sitting in a jail cell where, I mean, even though the defendant is awaiting trial and has not yet been proven guilty, there's still probable cause to believe that he should be detained, and there's a much diminished level of privacy for inmates. And their cells can be tossed at any time, and their phone calls are monitored, their visitors are monitored. So,
was this defendant in custody at the time in 2016 or on release?
I believe he was in custody.
Anything else you'd like to add?
Very briefly, Your Honor, just as a general matter, State v. Novembrino says that an informant's hearsay can be the entire basis of probable cause in an affidavit. And here we do have an assistant prosecutor who's a sworn officer of the court getting from police reports. And
don't you agree that basis of knowledge should be included?
A basis of knowledge should be included, but just as a general practice, hearsay is the entirety of the affidavit.
Of course, but even in those informant cases, the affiant says he got it from an informant.
Correct.
He doesn't give a straight narrative like in this case.
Correct.
He's not writing a novel. He's saying, I got information from informant A, and he puts it in. And he says, informant A was at the scene, or I've known informant A for 10 years. But the basis for knowledge is there, correct?
Correct.
And should be in these affidavits.
And should be. I just wanted to make clear that as a general matter, that hearsay can be the entire basis of it.
Okay. Thank you.
Thank you.
Mr. Paravecchia.
Thank you, Mr. Chief Justice. May it please the Court. In its published opinion, the Appellate Division mandates that the State achieve a novel, heightened standard of probable cause in order to acquire a defendant's DNA via a minimally intrusive buccal swab for forensic comparison purposes. So this decision must be reversed. Without this Court's intervention, it is reasonable to see how the Appellate Division's decision and their expansion of the meaning of probable cause will reshape Fourth Amendment jurisprudence in this state and infect other applications and effectively eviscerate the workable and reasonable standard of probable cause as we know it.
But you're not arguing against a basis of knowledge in an affidavit or a certification?
No, I think that would be the much more prudent response, Justice Timpone. I think, and I can speak from, as a rep, on behalf of the County Prosecutors Association, the Mercer County Prosecutor's Office, in response to the Appellate Division's decision, has not been drafting prosecutor-derived certifications. We have been getting law enforcement officers, detectives from our office to generate these certifications in support of the buccal swab warrants. So I would certainly agree that a basis of knowledge would be important. But the County Prosecutors Association fears the precedential effect that this new standard of probable cause will have on applications that are exceedingly more intrusive, more invasive, and that only require a well-grounded suspicion on which to succeed. As this Court is well aware, our state's probable cause jurisprudence is clear and well established. Probable cause is a fluid, non-technical, and flexible standard. It's not a high burden to meet. However, the Appellate Division's decision elevates probable cause to a burden beyond a preponderance of the evidence, beyond clear and convincing evidence, and even beyond proof beyond a reasonable doubt. Indeed, the Appellate Division is saying that in order to obtain a buccal swab, the state has to establish that DNA actually exists on the item of evidence. This is unprecedented, and it's unreasonable. It's unreasonable as asking the state to prove, in furtherance of a search warrant of a house, that evidence or contraband actually exists inside of that house before a warrant can be procured, rather than simply establishing a well-grounded suspicion that such evidence or contraband may be located therein.
But you have to prove that the house exists.
Absolutely, Mr. Chief Justice, absolutely.
So why don't you have to prove that the DNA exists?
Because it's a difference here when we're talking about a specific piece of evidence, which is the DNA. And in the search warrant analogy that I just made, we're talking about contraband or evidence. The specific pieces of evidence that I'm trying to analogize. DNA, or, for example, in a search warrant, the existence of drugs or guns. Take, for example, a search warrant trying to procure a blood draw to test for intoxicants for a suspected drunk driver. The state does not have to establish that intoxicants actually exist inside of that suspect's body in order to establish probable cause. Rather, the state would just simply have to establish a well-grounded suspicion that the defendant, that their blood may contain intoxicants.
Right, that's assumed. When the person reeks from alcohol, we assume that it's in that person's blood.
But let's say
so that is like a common assumption. Can we make the same assumption? Gun here, therefore, DNA evidence always on it? Or 50% on it, or 25% of times on it? Can you represent to us the percentage of times that DNA will be found on a gun?
I cannot, Justice Alvin. But what I can tell you is that...
But given your example, we can assume, almost to a certainty, when a person reeks of alcohol, there's going to be alcohol found in that person's blood, correct?
Correct.
To some degree or other.
Correct. But what about in a
the
situation
reality
where
is,
you're dealing...
isn't it just fair to say the reality is that this particular combination of concerns does not have an exact analogy elsewhere in Fourth Amendment law?
Yes.
So, isn't this one of those situations where it needs its own specific analysis that is going to differ from the analysis that applies to just about everything else?
Not necessarily, because still the application is still founded on probable cause. It's still a search. It's a search, and therefore, in order for the state to succeed in seeking a search, they have to establish probable cause. So I would say that, yeah, we may be dealing with a different type of search here, but it doesn't change what is required in order to.
Do you think that based upon this, you could draw the person, based upon your argument, a blood draw would be permissible?
Would you repeat the question, Justice Alvin?
The same facts as this case, and I want to get the defendant's DNA, but I'm not going to do the buccal swab. I'm going to take his blood.
Right. Would we be able to do it on these facts?
Yeah.
No.
Why not?
Because there's no probable cause to believe that intoxicants would be located inside that person.
No, I'm talking about this case. Instead of doing the buccal swab, I want to check his DNA through his blood.
Mm-hmm. It's still, even though the intrusion is slightly more invasive, it is more invasive. Now we're dealing with the blood draw, and McNeely says that a blood draw is an intrusive search. We know that, but the same standard of probable cause would apply. I think that the state could succeed if that was the route to go. If we didn't have the buccal swab available to us, we could, if we establish probable cause, extract blood for the purpose of doing a comparison with any identifiable DNA that could be located on the weapon.
And as far as you're concerned, these facts, assuming that a buccal swab was not an available technique, a blood draw would be permissible.
From these facts, we know that there is a well-grounded suspicion to believe that this defendant possessed the weapon. We know that there was shots fired at a particular location. Police respond. There's a loaded .357 revolver, and then a simultaneous report. I'm sorry, that revolver is loaded, and there's one spent shell casing in that revolver. A simultaneous report of a man shot leads detectives to the hospital where they encountered the defendant. The defendant has clothing.
We know all those facts, but
right.
But there's no DNA on the gun. So what good is it? You have all those facts. That's great. Present it to a jury.
But the reality is that these guns are being swabbed for the presence of DNA, and the state cannot leave those swabs untested. To go into trial with swabs of a gun pursuant to the state police protocol, where these guns need to be swabbed, and to not do our due diligence and have those swabs compared for the presence of DNA, if a defense attorney would make the argument, they could suggest that is a reasonable doubt. Why didn't the state follow up?
You're glossing over one step.
Yes.
And that is, we sent it to the lab, ladies and gentlemen of the jury, and they said there's not enough DNA to compare to anything. We did our due diligence. What's wrong?
There's nothing wrong with that if the lab could accommodate that. And the lab cannot accommodate submissions for every possessory case to determine if the existence of DNA is on those weapons.
But you're not submitting every possessory case.
You're
submitting when you're ready to go to trial and you think it might have evidence, then you send hopefully both samples, but maybe one sample. And maybe there is a 2 or 3 day lag between when DNA, or 4 days or a week, DNA turns up on the evidence and you submit the buccal swab. Maybe there is that gap in time. But you're not doing it on every gun. I don't even know how many you're doing.
If I can represent,
please.
In the Mercer County Prosecutor's Office, most, if not all, of our gun possessory cases, we are seeking these types of comparisons, especially when we're dealing with a defendant.
You are swabbing them and sending them up?
When we're dealing with a detained defendant in light of criminal justice reform. Because we know that these motions have speedy trial components to them. They're going to exclude time. The sooner the better.
How and when are you getting the buccal swabs as a general rule?
How and when? When we are dealing with possessory gun offenses with detained defendants, most if not all of those cases, we are seeking these applications.
Are you proceeding by way of an affidavit or certification after the fact, or are you doing it at the time of booking?
Not at the time of booking, Mr. Chief Justice. We are doing it similar to the way that it was done in this case. It would be a motion that's essentially a search warrant.
So you are treating this as a search. We're not in the realm of special needs and any of that analysis for buccal swabs, right?
Correct, Justice LeBecq. Yeah, we're treating it as a search.
Okay.
Anything you'd like to add?
No, Mr. Chief Justice. Thank you very much.
Thank you. Ms. Hudson.
Thank you, Your Honors. Good afternoon first. May it please the Court. At the outset, Your Honors, I would like to briefly address the mootness of the issue as Your Honor had addressed when Your Honors first came to the bench. In this case, the state based its argument on the fact that it was not able to test a gun or to test for a DNA profile without having a buccal swab. On Friday, April 20th, just this past Friday, we learned that that was not true. We learned that that, in fact, was accurate. Not only was a DNA sample taken off of the gun, but it went further to make a determination that there was insufficient DNA on the gun altogether. In addition to that, Justices,
We've been called worse.
By each other.
Sorry. The point is this, is that they're able to do the very thing that they keep saying that they can't do. And we know that's true by virtue of the lab report that they submitted. There was a quick turnaround time, and that was proven by virtue of the lab report that was submitted. This issue is now moot, and the state is essentially asking for an advisory opinion, because any decision of this court will neither grant relief nor have any practical effect in this case, and therefore the state's petition should be dismissed. However, I will address the merits of the argument. The question before this court is whether or not the state can compel a defendant to provide a buccal swab for DNA testing where that defendant has previously provided a DNA sample in connection with a prior conviction. Your Honors, I would submit that the answer to that question is no. The appellate division properly held that the search sought here by the state was unreasonable. And in coming to that conclusion, that court took into consideration a number of factors: the timing, the level of intrusion, the state's need, and whether or not the state had established probable cause, specifically by inquiring whether or not there was a DNA profile on the gun and whether or not the state had access to Mr. Gather's DNA from some other source. Both federal and state constitutions protect all people against unreasonable searches and seizures. As I'm sure Your Honors all know, that New Jersey's Constitution affords its citizens even greater protections than that of the federal Constitution. And there's no question that a buccal swab is a search under the law. And as the appellate division noted, the ultimate measure of a governmental search is reasonableness. And the manner in which we assess reasonableness is by comparing the state's need to that of a person's expectation of privacy as well as the depth of the intrusion. What is at stake here is a physical intrusion by the state onto the body of a person. That intrusion is a search, the need for which probable cause must be established. On appeal, the state continues to argue, and even today they argued, that the court in Gathers elevated or changed the standard of probable cause. But, Your Honors, that is a mischaracterization of the holding in Gathers. Instead, what the court did was merely enforce the probable cause standard as it stands right now. The state is urging this court to set aside the framework set forth by Gathers and allow it to conduct searches without properly establishing probable cause, all for the benefit of the state and for the state.
If the standard is that the gun actually has DNA, a testable sample DNA on it, there's no longer probable cause. It's not a probable cause standard. It's a certainty that the gun has some, and now you just seek to obtain it from the defendant. So doesn't that swallow the probable cause standard if the test is that the gun has to have DNA on it before the application for the buccal swab is made?
I'm sorry, Your Honor, could you restate the question?
If the standard you suggest is that the gun, there be evidence to the trial judge that the gun has DNA on it, testable DNA beforehand,
yes,
then there's no probable cause standard that you have probable cause to believe that the gun contains DNA. It's now a certainty. So doesn't that do away with the probable cause standard for the warrant if that's the way it's done?
Well, I guess my point is that when it comes to when the state is seeking to have a search and to take a buccal swab from an individual like they did here with Gathers, they need to establish that with respect to the gun that they're seeking to take this buccal swab to do DNA comparisons for, that there needs to be, at least at a minimum, they need to establish that there's a DNA profile on that gun.
Can't they just say that we have probable cause to believe that there's DNA profile on the gun because it was handled and the individual said he dropped it and it's missing one empty shell and he was shot himself once, Isn't that sufficient, or do they actually have to establish that the gun actually has DNA on it? That's what I'm asking you.
Okay.
What that does to the probable cause standard at that
Justice,
point.
and I understand now, Justice Fernandez, I would disagree that if merely stating that the person handled the gun would be enough to establish the probable cause. Because when we're talking about probable cause in the context of a search, it's whether or not that search will yield something of evidential value. What would be the evidential value that could be yielded from a search where you don't know if you're going to have something to compare it to?
But if we follow that, then would you have to establish that there was actually contraband in the house before you obtain the search warrant? It wouldn't be sufficient to say we believe there are illegal drugs in the house. You'd have to establish that the drugs are in the house, so we want a search warrant to search the house. Isn't that basically what you're doing with the gun?
No, because usually in those situations, the person that's making the application can point to some sort of indicia to indicate why they have substantive reason to believe that there would be contraband in the house. Like Justice,
That's why I suggested that the affidavit say he admitted he had a gun, he admitted he threw it down, we found it in the area, it has a spent casing. Isn't that sufficient?
No, I think that may be sufficient to establish probable cause for the charges, but not for the search.
Mm-hmm. What if the gun was found a block further away? I mean, what is the temporal proximity that's demonstrated in this record to tie this gun to this defendant's shooting of himself?
Well, that's the issue, actually, Justice LeVecchia, that I took with respect to this, because there was so much attenuation.
Mm-hmm.
The gun was found in a particular area behind the wheel of a car,
Mm-hmm.
and if anybody knows anything about the city of Jersey City, we know that that's not uncommon, that people often stash guns behind cars and things of that nature. So I think with respect to this issue, the facts as you just stated, I think there was too much attenuation to cause a person to believe that Mr. Gather's DNA, specifically his DNA, would be found on that gun.
Right, and to the extent there's pointing to the blurting out, does the blurting out provide any kind of connection to this device?
Well, here's the thing with respect to that. The state did highlight the fact that Mr. Gather said, so what, if I may have shot myself. However, they excluded the part of the statement where he originally told police that I was shot by someone. And the police came to their own conclusions, based on reasons I don't understand, came to their own conclusion that he shot himself. And in response to that, he indicated, so what if I did shoot myself? It's not a charge.
So the point of my question is the blurred out doesn't really get you there.
No.
And the proximity is a problem.
Correct.
Okay.
Yeah, would we have a different case if the buccal swab was taken at or about the time of arrest?
No, because New Jersey legislature has outlined the different offenses for which a buccal swab can be taken upon arrest. Merely possessing a handgun is not one of them.
So I know that statutorily, but the appellate division, and I'm quoting, timing is everything. That's what the court said. And then at another point in the opinion, the court said the impact of an intrusion at the time an individual is arrested is not the same as when it occurs later, while the individual is waiting trial. ... It seems as though for the appellate division, the analysis may very well have been different had the state not waited what the appellate division thought was an unreasonable amount of time before making this application.
I think in my reading of the appellate division's decision was that perhaps the search may have been more reasonable had it been earlier and had it met certain other circumstances, such as the circumstances met that were before the court in Maryland v. King. Those facts were never presented to the appellate division, as they noted, and I think that that's one of the reasons why they took issue with the fact that it took so long. But to answer your question, Justice Albin, I think that even had the search occurred earlier, say that they sought for this search to occur a month later, I still don't think that they had provided sufficient facts to establish the probable cause for the search. Because as I've already indicated, New Jersey legislature has outlined the different offenses under which a person can be required to give their DNA upon arrest.
What statute are you relying upon?
I'm relying upon 53-1 20.20.
I'm sorry, so
53
What about 20.22?
-120.
Can I get you to stay with 2020 first?
I'm sorry.
No, it's all right.
Yes.
Sure.
Are you looking at A?
Yes.
And
I'm looking, yes, DNA samples required.
so is there a difference between when it is required that DNA be taken and when an officer may take DNA?
Well, I guess an officer could still take DNA, but I think that they would still have to meet the standard under the search and seizure because still buccal swabs are protected.
So is there a constitutional impediment under Maryland versus King if an officer were to take a buccal swab at the time of booking?
I think that the concern would still be different from those or the facts that were in Maryland v. King. And what I mean by that is if they're not, let me back up for a second. If it's not one of the enumerated offenses that has been established, I think that New Jersey legislature has spoken to the fact that they don't think, well, under different circumstances, I think at that point a Fourth Amendment analysis would have to take place since New Jersey legislature has spoken to the very offenses under which a DNA sample can be taken upon arrest. So I think that an officer could still make an application for a buccal swab, however, they would still have to satisfy probable cause because there's nothing in the law as I read it that would just permit an officer to take a buccal swab just merely upon arrest. And if I may continue?
The 20 is the more pertinent statute.
Okay.
Thank you for addressing it.
You don't believe that Maryland versus King answers the question, in other words. Was there an
I don't.
application made in that case
For a DNA sample?
for the taking of the buccal swab, for the taking of the DNA sample?
It was my understanding from Maryland v. King at issue at the outset, Justice Rabner, is that at issue in Maryland v. King was the taking of a buccal swab of an individual arrested for a specific offense. Under the Maryland DNA Act, it allowed for the offense for which that person was arrested for that a buccal swab to be taken upon arrest. So I don't believe Maryland v. King has any sort of implications here because, again, the question or what was at issue before Maryland v. King was the constitutionality of the Maryland DNA Act. And just if I can just continue with a few other points.
Mm-hmm.
I would also like to note that at the outset, the state has noted that its lab policies prevent it from being able to conduct the very searches that were required by the appellate division, but we saw again, by virtue of the discovery that was submitted to us on Friday, that again is inaccurate. And while case law was clear that taking a buccal swab is one of the least intrusive methods to take DNA, it's still an intrusion nonetheless, as Justice Albin pointed out.
Let's talk about backlog because I think there's a distinction between what can be done if for some unknown reason the laboratory found itself with only one sample to deal with, and the reality is that it is extremely backlogged and not for lack of hard work, but because of the volume of samples that are submitted to it. If it is just unfeasible in terms of backlog, and this is not a priority over homicides, sexual assaults and the like, what's your response to that? Are we setting the bar to the point where it just can't be met?
I don't think we're setting the bar to the point where it can't be met because I think by virtue of the discovery that they submitted on Friday, it showed that there was a short turnaround time. In that 10-week period, they tested for a DNA profile and they determined that the DNA profile was insufficient and it was insufficient to submit in the CODIS. I think when we're talking about a person's constitutional rights, a person's constitutional rights should never, ever have to yield to a lab policy. And I think that that's why I believe that the court in Gathers was correct because they did what we would want any court to do, and that's protect people against these unreasonable searches and seizures. It's not reasonable to ask somebody to provide their DNA.
But I think what we're hearing from the state, if I'm understanding their argument, is that the advent of criminal justice reform and speedy trial is really changing the overall picture. Do you agree with that in terms of the ability of the lab to respond?
I think that it may be changing the overall picture. However, I think that the lab is still capable of doing it. And one thing I would like to note that within the state lab, there's a lot of different divisions. There's a forensic serology unit, a DNA unit, in addition to the CODIS unit. So they have all these resources that they do have, at least at a minimum, to establish at least that there's a DNA profile on the very item that they're seeking to have tested. Again, I think we cannot lose sight of the fact that it's somebody's constitutional rights that are at stake here. And while I can understand the concerns of a lab policy, I don't think that there's ever a situation where somebody's constitutional rights should be trumped by the state lab.
And I'm not suggesting that,
Okay.
but we're talking about practical difficulties and the issue of what is efficient and what can be done within a reasonable time. And that could affect defendants as well as the state's ability to prove their case.
Well, with respect to defendants, they always have the option, as with any search, to consent to the buccal swab. Just in this particular situation, they did not.
Ms. Hudson, is there anything else you'd like to add?
Yes, Justice, there's just a few things that I would like to add, if you don't mind. And I just want to be clear that we're not asking, as the state is suggesting, that that the state go into the CODIS database, physically retrieve Mr. Gather's DNA. We're not asking for that because we can see that that's not at all possible. Instead, what we're asking for is for them to establish that there's DNA on the gun, and if there is, to upload that into CODIS. This is what the lab does weekly, just as Justice Alvin pointed out. Weekly, there's DNA unknown samples that are uploaded into CODIS every week to determine if there's any sort of match, and that's what we're asking for here.
But you heard the state say the federal government has a policy that they're not doing this under circumstances like this. So the state can't do that without violating the federal regulations and therefore jeopardizing their right to participate in this whole CODIS system. That's what they're saying.
That's what they're saying. However, Your Honor, the same policy that they rely upon for that, the premise of that argument, which is, I believe, under Section 3112, that section goes on to allow for situations like these. And despite what the state says, we've seen from the lab report that was submitted to us on Friday that that's inaccurate and that they can do it.
So are there two different things in play here, and I want you to clarify for us.
Okay.
Figuring out if there is DNA in this particular swab that has been submitted and uploading it onto CODIS. Are those the same?
No, it's more like a two-step.
Right. So you were asking for the second.
Yes, as well.
What's the basis for saying that that's possible and still comply with federal requirements?
Well, one, as I've noted from the evidence lab receipt that we've received, it showed that it is possible. And then with respect to it violating...
I don't get
the,
that.
Where do you get that from?
That receipt,
I think it
that
answers
went
the
to
first
CODIS?
question, not the second.
Oh, that it's... I'm sorry, maybe perhaps I understood the question. Could you repeat the second?
You've argued to us that the state should upload these onto CODIS, as you've suggested they do. What's your basis for saying that can be done?
Well, Justices, if you look actually at the second page of the discovery that was submitted, to me, the way I read the third line where it says the DNA profile generated in this case fails to meet the criteria for entry into CODIS, to me, indicates had they had a sufficient profile, perhaps they could upload it into CODIS. And also, the basis of my knowledge also comes from just my day-to-day practice in the trial court, where routinely, just as early as last week, I had a situation where I received a lab report where the lab indicated we found DNA on this particular item, we took the DNA, and we're going to upload it into CODIS, and once we get...
That's where you have an unidentified defendant target, and/or it is, if for a gun, it's used in a gun crime.
No, in that case, they knew who their suspect was.
Why don't you
Can you tell us to the manual?
Yeah.
I'm sorry?
Can you tell us from the manual how what you're asking for is
Yes.
doable?
Under 3112, it says, while the defendant's possession of an item...
Do you have the appendix page that you're referring to?
I believe it's SA 57.
I'm sorry, what's the page number?
SA 57.
Thank you.
And it starts under 3112, where it says, while the defendant's possession of an item. Because under that section, they're talking about what is and what's not eligible for CODIS upload. Now, after it lists a number of different items that are not eligible, it goes on to note that, just to paraphrase, while the defendant's possession of an item illustrated by the list above may appear to resolve the eligibility issue, documentation of the scene of the crime or the item's use in the commission of a crime are important factors to consider in determining a DNA's record eligibility for upload into NDIS. And that, Your Honors, is a section that I read to interpret to permit the uploading of the DNA profile into CODIS.
So how is the gun different from the example that's listed a few lines above that? an item for which the suspect's profile could reasonably be expected to be found that is at the crime scene or as part of the crime scene, independent of the crime, for example, a car. That's not eligible. You're saying a gun is, but this tells us that a car isn't.
What I'm saying is that the lab does allow for within its policy some flexibility. That's what I'm saying, by virtue of what I'm reading.
I thought CODIS specifically did not allow for a possessory gun offense, but they do allow for guns used in the commission of a crime. You're saying that's not the case?
What I'm saying is, reading this section, it seems as though there's flexibility to do the testing.
It seems as though, but there simply may not be.
There simply may not be. What I'm saying is...
No, I got you.
Okay. And if I can just conclude, the court and gathers, as I previously stated, did what we would want any court to do, and that's protect people against unreasonable searches and seizures, such as the one sought here. I believe that the decision in gathers was legally sound, correct, and the decision should be upheld. And, Your Honors, that concludes my remarks.
One question before you sit down about mootness. You're familiar with the court's law that says if it is an issue of public importance, significant public importance that can be repeated yet evade review, that's something appropriate for the court to rule upon. I know a lot must have been happening rapidly on Friday.
Yes.
Is it the position of the public defender up the chain that this case should not be addressed and is not a matter of public importance?
Well, I think that it is obviously a matter of public importance. I can say that, and I would think that the public defender would perhaps agree.
Okay, that's helpful. Thank you.
And you'll give him a call later.
I'll stop down on
Tell
the
him
floor
what
on
you
the way out.
committed to.
Ms. Borden.
Good afternoon. May it please the court. In closing, Ms. Davis-Ellison said that this case would guide the office moving forward. And precisely for that reason and for the guidance that the court can here provide, we submit at the ACLU that this is indeed of great public importance. So I'd like to make 3 quick points. I know I'm last in the lineup, so I'll try to be brief. The first on Maryland v. King and the reasons it does not control this case. The second, very briefly, on probable cause and the 2-step analysis we've been discussing here today. And thirdly, on the intrusiveness and the privacy interest at play. So just by way of framing, the Attorney General's office talks about cell searches and the sort of lesser expectation of privacy that is afforded to people taken into custody. And I think it's really important to underline that that may be a reduced expectation of privacy, but it's not, it doesn't vitiate the Fourth Amendment altogether. So that is to say, Hudson v. Palmer and that whole line of cases stands for the proposition that an inmate certainly has some reduced expectation of privacy, but we wouldn't allow, that case was about strip searches, although we may allow sort of a search of the cell, we wouldn't allow strip searches just in the middle of the night for no other reason. And so I think that as a framing point is very important to ground all of this. On Maryland v. King, Chief Justice, you asked whether Mr. Gathers could have been searched, could have had a buccal swab taken when he was arrested. We submit he could not have. And Ms. Hudson eloquently explained why there's no statutory authority. I think that the legislature's silence in enumerating just a very few offenses, I think the silence suggests that the legislature did not mean for a buccal swab to be permissible upon arrest for all other offenses. But there are 2 other reasons that Maryland v. King doesn't control. The first is here because it's not upon arrest. It's 10 months later. And so, as the appellate division said, timing really does matter. And I don't think that the state and its amici submit that that they don't need probable cause in this case, that 10-month lapse can still rest upon whatever authority may have been present upon arrest. But I think the crux of the matter is that this court has a long and admirable history of affording more protections to criminal defendants under Article 1, Paragraph 7 than the federal government, than is found under the federal Constitution. And so it is the case that Maryland v. King holds that under the federal Constitution, it is not unreasonable to search defendant upon arrest. That says nothing about whether it's permissible under Paragraph 7. I don't believe this court has considered it. I don't believe this case requires you to consider it, but I would urge you to afford more protections here, and there are a couple of reasons why. First of all, In O'Hagan, 11 years ago, obviously pre-Maryland v. King, but in O'Hagan, this court looked explicitly to Sampson, and in Sampson, the U.S. Supreme Court considered the reasonableness of a search where there was no individualized suspicion, and it decided to take a totality of the circumstances, reasonableness, balancing approach. In O'Hagan and in AA the same day, this court considered those searches where there is no individualized suspicion, and it looked at Sampson, the case of the parolee, of course, and it looked at all the other courts that had considered searches without individualized suspicion. And it acknowledged that although DNA acts in other states had been upheld in all those cases, different courts did it different ways. Some went with the sort of more permissible totality of the circumstances, some went with special needs. And this court explicitly said in O'Hagan, we're going with special needs. And my mentor over there tells me I shouldn't bring cases up, but I want to just point to one citation that I think is important.
Because he never does.
I know, but I'm not him yet. In St. V. O'Hagan at page 158, this court wrote, the more stringent special needs analysis provides an appropriate framework for evaluating defendants' New Jersey state constitutional claims. So I think that's really important. And I think if this court wanted to consider whether special needs would be appropriate, which again is not the case 10 months later where we need probable cause, and I think the state and Itsamichi would agree with me there, but if this court wanted to, it would basically have to either overrule O'Hagan or it would create a split in the jurisprudence where somehow we need probable cause for those convicted of a crime, where somehow we need special needs, the more protective analysis for those convicted of a crime, which is what Your Honors found, or the court found in O'Hagan and AA, and yet the more permissive totality for those arrested and still presumed legally innocent. So I think it's just simply the case that this court has already said we're going to go with more protection. Again, I don't think Maryland v. King's application is before the court in this case, but to the extent you consider it, I think special needs was the right way to go 11 years ago in considering
the special
the DNA.
needs is not a situation like we have here, where they're
Absolutely.
getting evidence to try
Absolutely.
to direct an investigation at the donor.
Yes.
I mean, O'Hagan and its companion case, AA, specifically separated out that was not at stake in O'Hagan and AA. So
Yes.
I
Absolutely, Justice.
I think we're
Levin.
dealing with entirely different situation here.
Absolutely. And that brings me to point two, because I think you're absolutely right. I just wanted to...
Please don't go to point two just yet, but finish that answer.
Okay. Well, I just wanted to sort of put a pin in that question, perhaps for a later day. I think when this court in O'Hagan and AA upheld the constitutionality of the DNA Act, this court actually just looked at the constitutionality of swabbing defendants upon conviction, individuals upon conviction.
Right.
Of course, the DNA Act at 53-1-2020 also includes swabbing upon arrest for sexual offenses, murder, manslaughter, etc. I actually don't believe I haven't read all the briefing, but in its opinion and the oral argument, the court didn't address the interests at play for arrestees. I don't think this case
would
is
have
that.
to be different.
Of
Because
course.
since you're dealing with a class of convicted people,
Yes.
you couldn't possibly be using the probable cause standard. So the only applicable
Exactly.
approach would have been special needs, because we weren't able to use the conventional
Exactly,
means
Justice
of...
Alvin. And I think I made a slip of the tongue earlier and said probable cause when I meant to say special needs and tried to correct myself. You're absolutely right. The court did and properly use special needs rather than totality of the circumstances. Probable cause wasn't considered at all. So O'Hagan and that line of cases in the DNA Acts considered elsewhere look at the absence of individualized suspicion.
And that's what I was going to clarify. You're not suggesting that a special needs analysis is
Absolutely
more
not.
onerous than a probable cause analysis.
No,
It's actually less.
Exactly. It's more onerous, though, than a totality. And the totality test is what the U.S. Supreme Court used in Maryland v. King, which, of course, was post-dated O'Hagan, but it's also what it used in Sampson. And so my point is just I don't think this issue is before us as Justice Lavecchia raises, but because Chief Justice, you asked the question, and I think it was you, I wrote down your name so often for various points I had meant to make. I think it was you, Justice Alvin, who also asked. I just wanted to put a pin in it and say Maryland v. King does not control, because that case came up quite often, and I think it's important that we're not there. We are, if I may, Chief Justice, go to point two, we are in the realm of probable cause. And so this search is not special needs. It is the quintessential law enforcement purpose for which probable cause is required. And I think Ms. Hudson did a phenomenal job explaining, so I just want to make a couple of really quick points about the probable cause that's
But
required
before you
here.
do, where are you on the basis of knowledge discussion that we had
Yes.
earlier?
So I think I will explain. I think I'm somewhere in the middle. I'm at a probability. So probable cause here properly is a two-step process. And we talked about the two steps, right? Step one is there needs to be some DNA profile on the gun or the cache, or frankly, a pool of fresh blood. And step two is there needs to be a linkage. So to your question, Justice Timpone, about the sort of knowledge, I think it's hard to say. I think if the state had an expert who said, we know on guns there is always X percentage of cases in which we can pull a veritable DNA profile, and that X were something that was the basis of, well-grounded suspicion.
Where do you draw that line? Why would the expert have to say X? Why couldn't the expert simply say we frequently, just like fingerprints, we frequently find DNA on guns that have been handled by a defendant? It might be 1%, it might be 0.5%.
Well, and I think that's why probable cause is ultimately, unfortunately, an art and not a science. I think if we did have X and X were big enough, that would be probable cause.
How big is big enough in a probable cause? Why does it have to be that? Maybe it's 1 in 100,000.
I think it does have to be probable, any more than we could say on a carpet right there. I think just logically, there needs to be some predicate before we can swab a defendant that defendant's DNA will somehow link to.
What's the number?
I don't think there's a magic number. I think it needs to be, as is always the case in probable cause, not a likelihood, not an absolute, and I don't think the appellate division suggested it needed to be an absolute, but there needs to be some probability. And I think police and I think courts who issue warrants, are in the business of this. I, at the ACLU, am not.
Well, one of the terms that I heard in our discussion was a well-grounded suspicion.
Yes.
Where are you with that?
I think that's the standard. I don't know that a well-grounded suspicion translates into X percentage, though. But I think it needs to be more than a hunch, right? This court has often said, in the context of reasonable suspicion.
Is possibility enough as opposed to probability?
I think possibility is enough as long as it's something, right? And I think it was the Chief Justice who asked about $1 or $100 bill, a piece of paper. I think let's take the case of a fresh.
I don't think our jurisprudence is going to support possibility.
Oh, you don't know. I haven't voted yet.
Then our future jurisprudence.
Touché. Well, I hope to be here for the future, Justice Alvin. I am presently pro-hocked in, so I will defer on that. But I think, take a pool of fresh blood. I don't think the ACLU or the public defenders would say, if it really were fresh, you have to test and make sure you can get a DNA profile there. I think we could assume that if there's fresh blood, there's going to be some DNA profile there. It doesn't need to be an absolute, but there has to be something. Probable cause works in this gray area of possibilities, if not probabilities, and there needs to be something there to suggest that we will find a DNA profile. The point I actually wanted to focus on, though, was the second part of that two-step process, which is the linkage. And I think it was Justice Patterson who said there needs to be some link still. And that's the case, because just because there's DNA, let's say we actually do know that the lab results that we read on Friday afternoon actually said the opposite. There is a DNA profile in there. That would still not be sufficient to go and get a buccal swab of defendant, any more than it would be to go and get a buccal swab from me, because there's probable cause still requires that there be evidence of the crime found, right? And of course, swabbing Mr. Gathers is going to find evidence of his own DNA, that's for sure. But what we need to know is, will his own DNA link him to the DNA that we now hypothetically know is on the gun? And so in order to do that, the state could do a couple things. We in the Public Defender's Office submit that they could have actually run whatever DNA they found on the gun in CODIS. We had a discussion around that. I won't get into it. But assuming they could run it in CODIS, as they could, as Justice Alvin said earlier, if they didn't know who the suspect was, if there was then a hit CODIS is created specifically to provide that probable cause. And I think in her appendix, Ms. Hudson included an example of a letter from the laboratory to law enforcement saying, we've got a hit, maybe
But
go get a warrant.
I think what we are hearing from the state is that CODIS is not interested
Right.
in devoting very limited resources to possessory crimes, and that's all this
Right.
would ever be.
Right.
It's not about a homicide or attempted murder or anything along those
Sure.
lines.
And be that as it may, so assuming, I won't concede it, but assuming for purposes of argument that that's so, take CODIS out of it entirely. There's still no linkage between the defendant's DNA and the DNA that we're pretending was found on the gun.
Okay,
And
so where do
we
they go to
submit
get that linkage?
Anywhere they otherwise get probable cause. It's a fact-intensive question here whether or not there's probable cause because...
So your position is that if this had come out differently and there was DNA,
Yes.
that and CODIS turned out for whatever reasons of policy to be unavailable to them,
Yes.
they still don't have enough.
I believe that's so, because they wouldn't have, unless there's something linking Mr. Gathers to the DNA on that gun, it's like saying, hey, guess what, we found a DNA profile on the gun, test
Didn't
board
they
and we're
already
coming for your
establish
DNA.
that probable cause in charging him with the gun? Isn't that already in the AG's, the assistant prosecutor's certification and the police reports?
Yes, and I think on these facts, that probable cause is weak. But that's
Probable
a fact.
cause is weak, or your argument is weak?
Well, I would hope it's the probable cause.
Okay, I just asked.
They charged him with possession of a gun that they didn't necessarily have.
Exactly.
And the evidence
Thank
was
you,
that he
Judge
shot
Slovak.
himself.
Yeah, exactly,
Right.
exactly. And I think if Jersey City were a smaller city, if the linkage here on these facts, but I don't think that's for this court to decide, is that a man was shot by himself or someone else, Ms. Hudson suggested possibly, and a gun was found. Whether or not that's sufficient is not for this court to decide. As amicus, I'm suggesting simply that there's still, probable cause here is a two-step process, and there still needs to be some linkage between the defendant's DNA and the DNA on the
Isn't
gun.
his statement that he threw the gun and he shot himself and he threw the gun out, wouldn't that be sufficient?
Depends on where they found it.
I don't think so. I think it could be, as Justice Lavecchia
How do
points
you,
out,
how do you
any
ever,
gun.
how do you ever tie him in?
I'm
Short,
sorry, I didn't hear
short
you.
of a confession, how do you tie him in? You found DNA on the gun. The gun was found in the street. You have a statement that he shot himself. It's not a crime, and he threw the gun somewhere.
Right, and I think that there could
if
be
that's
many,
not enough, then how could you ever possibly
I think
match it to
all
him?
all the ways, Justice, that the
Such
police
as?
always get probable cause. An
Help me
eyewitness
out.
saw him.
I'm trying to think of something, 'cause
Yeah.
I can't come
I
up with
think
any.
a credible eyewitness. I think a credible eyewitness or something that locates him in that area.
Probably-
Take the facts of this case.
Yes.
Suppose the lab report came back
Yes.
and said, there's enough DNA for a comparison. Are you saying there's not enough probable cause at that point to submit a certification and say, we now want a buccal swab?
I don't think that fact question is before this court.
It isn't.
I
But it
would
sounded
say,
like you are
as the
arguing.
ACLU, that if that is really sufficient probable cause, then we're absolutely fine with it. We don't believe that a search, a buccal swab, needs to be supported by a hit in CODIS. And I think all the arguments about that are a little bit of a red herring. We submit simply that this is not O'Hagan and AA, so it needs to be supported by individualized suspicion, the standard of which in this case is probable cause, and we don't need to get into what that probable cause looks like. I think if there were that certification and a court decided that it was sufficient to support a warrant, that we would be all right with that.
Thank you.
May I speak briefly to the third point?
Yes.
So the third point is about the intrusiveness of the search, and I think it's quite clear that this court can and should decide the question on probable cause alone, especially in light of the development on Friday. But to the extent the court wishes to consider the intrusiveness of the search or the privacy interest at play, I think in particular given what the Attorney General's office raised, that it's this is minimally intrusive, I think it's important just that we speak to it quite briefly. And so Justice Scalia, obviously in his dissent in Maryland v. King, said something beautiful about the framers not wanting to open their mouths up for royal inspection. And that may be so, but we submit this is actually much more than just opening one's mouth, which I can't do to speak. In creating CODIS, the federal government was actually quite attuned to the privacy implications and even potential for misuse. And that's why CODIS is de-identified. That's why we can't go and search for Tariq Gathers' name in CODIS explicitly. That's why a whole group of privacy advocates were brought in when CODIS was created to advise on the privacy implications. And this court considered in O'Hagan and AA the sort of analogy of DNA to a barcode. I think it was you, Justice Alban, who talked about it being a barcode. And I think that's very helpful. But I would actually encourage this court to think about everything else, right? Because this isn't just the barcode that the police are looking at. This is the entire supermarket, and then the police are going in and clipping out the barcode on one cereal box. Or if that metaphor is faulty, it's the police, it's saying turn over your entire house for police search and trust us when we say they're only looking inside your kitchen cabinet. And so while it's the case for sure that CODIS only looks at 13 loci, the sort of junk DNA, those STRs, which don't contain that much good stuff, the police obviously can't just swab for those 13 loci. When they swab, they're taking everything, and then we're just trusting them only to look at those specific STRs. And so I just want to speak really quickly to the three things that are contained in that swab that they take away.
And please try to wrap up your argument as you're doing so, because
Yes.
we're about 20 minutes, a little over the 5-minute mark. Go ahead.
Okay, time flies. First,
Not over here.
I don't know if it's an advantage that I didn't hear you.
I was just kidding.
Let's go right to the 3 points. Go ahead.
Point one, it's not just a barcode, it's my entire genetic identity. It's my code, it's what will allow me or my grandchildren one day to be cloned. I think they did it with sheep a couple of years ago. Point two, it's all my genetic vulnerabilities, my predispositions to certain health conditions. It's why people agonize about whether to get genetic testing in my family, about whether to get the BRCA gene test. It's why parents have heated conversations about whether to engage in prenatal screenings. And third, it's not just my vulnerabilities, it's that of my entire family, all my genetic relations, right? So it's my sister, it's my parents, it's my future children and my grandchildren. And so to be sure, this big brother concern is not what CODIS is being used for. I want to be very clear. But I think in today's age of massive private data breaches and pretty widespread government distrust, it's a lot to ask Americans to turn over their entire genetic code and that of all their families and then just trust the government that they're only going to look at those 13 loci. And so in conclusion, I would just say, I think this case can and should be decided on the probable cause analysis. But if this court wants to consider the intrusiveness of that swab, we would encourage your honors to not think about the physical intrusion of that 10 seconds so much as all the information that the Q-tip carries away with it.
Thank you.
Thank you.
I know it's late in the day. Ms. Leonard, I have 2 questions, and I'm hoping you can help us with them. Would you mind coming to the center? One is a follow-up I should have asked earlier. I asked you if the Attorney General concedes that probable cause is the required showing. You said, no, we don't concede that. What do you believe the appropriate standard should be, if not probable cause?
Well, I think in Maryland v. King, the court likened a buccal swab to fingerprinting and the types of, and photographs, the normal booking procedures. And we do have statutes that allow for a buccal swab upon arrest, and then a broader statute that covers for more upon conviction for more crimes. So I don't know that a probable cause showing is required.
Can you tell us what standard should apply? Are you able to do so now?
I believe that it's upon booking, it seems to be, by Maryland v. King, it seems to be almost automatic that it can be done at the same time as fingerprinting and photographs.
And my second area, the statute we've been cited to, which I've glanced at during the argument, speaks to taking DNA samples on conviction, I think, 2020, 53:1-2020.
Yes.
Are samples taken at the time of arrest, and based on what authority, if you know?
There are samples taken upon arrest for certain qualifying offenses. Those are the sexual-based crimes and violent crimes. I didn't bring with me the statutes.
That's all right. We'll find it if you don't have it. Can the state help on that score?
You're saying it's a statutory provision that deals with certain crimes.
It is a statutory provision that deals with certain crimes. But even if the statute doesn't provide for it, I think that Maryland v. King covers it and says that that the buccal swab, since it is like a fingerprint and a booking photograph, it could be taken at the time of arrest, even if it's not covered by the statute.
Thank you. I'm looking over at the state. I don't see a ready answer. Is that fair? All right. Thank you. Come to the center if you could.
Thank you.
No, I'd appreciate it. Come to the center so that your words will be preserved.
The statute that deals with the specific enumerated offenses is one that I cited to earlier, which was 53:1-20.20. And there it lists aggravated sexual assault, manslaughter, as well as murder.
What section are you looking at?
Well, I'm talking about for taking buccal swabs upon arrest, I believe, or
Yes.
convicted. Yeah.
Which section of the statute are you looking at for that? That's what I was asking.
Okay.
But it says on conviction.
Yes, upon conviction.
A is conviction. I was
Right.
looking for authority for arrest.
My apologies, I misunderstood the question.
Anybody else have an
All right.
answer? All right.
Your Honor, if I may.
Please.
In 2020, at subsection I, it says that nothing in this act shall
Yes, that's a catch-all. Is there any precise authority?
I know that there is, but I can't find the precise answer right now, but I can follow up with a letter,
Well,
Your Honor.
is
We have
20-20
an answer here.
We have an
Is 20-20 the subsection? Is 20-20 the subsection? Because A says every person arrested for an offense enumerated in this subsection shall provide a DNA sample. If 20-20 is
the
the
very end.
subsection,
Thank you.
then
Okay.
it would be all of the crimes that are listed in 20.20, which
Yes.
includes sexual assaults, murder.
Thank you, Justice Allen.
Thank you, Your Honor.
You make a very good law clerk.
20-22.
What?
20.22.
20.20.
Court is in recess.